Hi, this is Seema Arora, and this is a podcast on sustainability, climate and business, economy, and tech. Today's case, we're talking about the landmark ruling against Google that was announced by Judge Mehta, saying that it has indulged in anti competitive practices and is therefore liable under Section 2 of the Sherman Act. This case is monumental in its significance. Big tech is under scrutiny by the Department of Justice, and therefore, this case has widespread repercussions across tech. Today, we'll discuss about how this case was brought about. So it would go beyond the sound bites that we see in the everyday stories, and we will try to see what happened in the courtroom and what evidence was presented for this ruling to come out. So, without wasting any more time, I'm going to introduce the guest on the show. His name is Dr. Gregory Werden, and he's worked at the Antitrust Division of the US Department of Justice for over 40 years. Prepared numerous guidelines and 100 briefs filed in the appellate courts of the Supreme Court. He's the only antitrust division employee ever to get the department's Mary C. Lawton Lifetime Service Award. And after retiring from government service in 2019, he has written a book titled The Foundations of Antitrust Events, Ideas, and Doctrines, which is very lucidly written and is a great treat for people who want to explore the field of antitrust with lots of good legal knowledge, economics, and a very readable description. He earned his PhD in economics from University of Wisconsin. So I would like to invite you and start off by uh, asking you to describe in this case, we want to dissect the decision about how this happened and the role of the antitrust in bringing about this case. So may I please give the mic to you now?
Thank you. Let me just say that in my 40 plus years at the Antitrust Division, I came to become as much a lawyer as an economist. I realized early on that lawyers didn't take economists seriously. Their favorite line is, "You don't understand the law." Well, that is remediable. You can go to the library. Law is easy. You just have to read it, think about it, talk about it with people, and then you know it. It's not like quantum mechanics. So early on in my career, I decided that I would know the law as well or better than any of my colleagues. And I studied it on my own. And one of the things I came to appreciate is that it's taught badly. And it's taught badly because the way of teaching antitrust has never evolved. Antitrust is a fairly modern field. It dates from the late 19th century. And it was introduced just after law came up with the case method, where law is taught by talking about individual cases. And I came to realize, well, that's not the way to understand law, at least not antitrust law, because you need to read 1,000 cases to understand a single point,
Yeah.
because it's not like a cookbook. That's the way it was usually understood. You put a practice in a particular compartment, and then you know whether it's legal or not, or how to determine whether it's legal. And that's not how it works. And it's not how it worked in the Google case. Although there's a lot of the opinion about which pigeonhole the conduct goes in and what the consequences of that are. Ultimately, the question is, well, what is the effect? And that's always the question.
Yeah.
So you need to structure that inquiry. And you need, and that is a very complex endeavor. The Google case is governed by the Sherman Act of 1890. So
Yeah.
late 19th century.
Mm-hmm.
There is some very limited common law before 1890 that's in a similar vein, much more
Mm-hmm.
limited than is generally said. It's
Mm-hmm.
reviewed in my book. And the Congress in 1890 didn't really know what they wanted to prohibit and what they wanted to allow. So they wrote these very vague provisions using some undefined terms. And they left it to the judges to figure it all out. Supreme
Yeah.
Court has said several times that this is the system of antitrust in the United States. It's judge-made law.
Yeah.
Well, that's not favored, but that's the way it is in antitrust.
Yeah.
What is crystal clear is the Sherman Act does not prohibit monopoly itself.
Correct.
Rather, it prohibits obtaining or maintaining a monopoly through anti-competitive exclusionary conduct. The problem
Yeah.
is, it's not so easy to decide what conduct is exclusionary.
Mm-hmm.
It is accepted that competition on the merits is lawful, even if it does result in monopoly or maintain monopoly. And Google has argued that that's all it did. It competed on the merits. I largely agree, but Judge Mehta saw it a different way.
Yeah. Interesting. So, first of all, thanks very much for clarifying and telling us a history about the case law versus the common law and the context of the Sherman Act. A very important point that monopoly per se is okay is the anti competitive practices that are subject to violations. So, you've told us the punchline here already that you disagree with Judge Mehta's ruling. I want you to walk through some of the arguments that were made in the case, and in doing that come out with how the case was presented, what lines of inquiry were pursued, Google's primacy in search. That was kind of the starting point of the case, and how it has, in the view of the court, engaged in practices that were anti competitive. So let's walk through all the arguments that were made in the case. And of course, in the end, and we know now that the big question, and of course, the ruling has already been passed, but the big question is, did Google maintain the monopoly based on merit and innovation, or did it achieve it through so called exclusionary anti competitive practices? So that's really the interpretation of the law. And I would very much appreciate, your taking the uh, points that they were making in the courtroom regarding how those practices were exclusionary.
Yeah. Sure. Let me note that I have to do this at a high level. This was a complicated case. The trial went on for, I think, 6 weeks.
Hmm.
There are tens of thousand pages in the record. So, I'm going to skip over a lot of fine points. It should also be observed that Judge Mehta's opinion is 277 pages long.
Right.
So, he gets into the case in a great deal of detail. And for the most part, it's a very good opinion. He is a good judge.
Hmm.
But I don't think he saw the competition exactly the right way. But let's go back to the beginning. So in the beginning, there were other search engines. There was Alta Vista. And then later there was Internet Explorer. And Internet Explorer was competing head to head with Netscape Navigator when Google was it wasn't the first
1990.
search engine, but it was the first search engine to be based on an index of the entire internet. It was a different idea for how to do a search engine. It didn't seem to some people the best idea because it was so hard to do.
Hmm.
But through huge effort over a number of years, the Google idea was brought to fruition, and it quickly became the leading search engine. But there wasn't yet a sustainable business model. But early in the 20th, search advertising became a significant thing. And then the business model started to take shape.
Hmm.
It was all about advertising revenue.
Yes.
Everything, at least the main things I'm going to talk about, that Google has done has been directed at bringing in more advertising dollars. And the basic way you do that to build your user base. So what do you do? Well, you make your search engine better.
Yeah.
You include it in a quality browser. So they developed Google Chrome. You realize that the future is mobile. So you go in to the mobile space big with the Android operating system and a whole alternative to the existing mobile devices. Maybe Google had lots of ideas for how they were going to make money, but the only one that is really come to fruition is advertising revenue.
Yeah.
And it's been very profitable for Google. And most everything that's relevant to this case has to be understood in that light.
Yeah.
And to a considerable extent, Judge Mehta did understand it in that light. He observed early on in his opinion that it's all about advertising revenue, and the way to get advertising revenue is to increase the user base. And so that's what Google set about doing. Well, he could have added that that's what any rational business would have done. And Google was just smarter about it, and quicker about it, and better about it than its rivals. But he did say some of that, particularly with respect to mobile. So what the case mostly focuses on is partnerships that Google entered into in order to promote the use of Google search. So who do you partner with? You partner with anybody who is a distributor of search engines. So for example, that is browser developers, because browsers use search engines. And so who are the browser developers? Well, there's Microsoft, but they don't want to partner with Google. They have their own search engine. There's Apple, and they partnered with Apple. There's Mozilla and Firefox search engine. They partnered with Mozilla. There's Opera and the Opera browser. They partnered with Opera. In each case, they offered a share of the advertising revenue in exchange for distribution. The details of the agreement, to me, don't seem terribly important. The idea of the agreement is obvious. It would have been hit upon sooner or later, if not by Google, then by the partners. And the reason the partners would have hit upon it is it was their only path to monetize their search engines, their browsers. A browser doesn't generate revenue. Nobody buys a browser, rents a browser, pays a monthly fee to use a browser. That's been tried. There was one browser that you probably never heard of that was on that model. It failed because people didn't want to pay a subscription fee. And Microsoft's probably responsible for this. Early on, it promoted Internet Explorer, distributed it with Windows, provided it for free. And at that point, it became infeasible to compete in the browser space and charge customers. There's talk about the power of free.
That was the case. Yeah.
Okay. Well, yes, that's powerful. I'm a consumer. I respond to that. I'll take free. So what's left? If you can't sell the browser, rent the browser, then you have to take on a partner to get revenue. That partner has to be a search engine developer. So who's it going to be? Well, there's basically only two possible partners, Microsoft and Google.
Yeah.
And Mozilla did partner with Yahoo for a while, but that didn't work.
Yeah.
And so there's Apple. Apple has talked to Microsoft several times, but Microsoft cannot bring in the revenue that Google brings in. So Apple indicates to Microsoft, well, sure, we'll take on you instead of Google if you can give us the same revenue. And Microsoft says, we can't do that. And Apple says, we know. So who are they going to partner with? So I don't think there's any question that in a free market, you would have had a partnership between Google and browser developers. The question is, on what terms? And the issue isn't the revenue split. Nobody's making a big deal out of that. The issue is Google wrote the contracts in the way lawyers write contracts. The contract says, you will do this for us and we will do this for you.
Yeah.
That's the way people write contracts. Judge Mehta says, no, 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 no. That's exclusionary. The contracts shouldn't say that you will do this for us, you, the browser developer, doing for Google. The
Hmm.
contract should be written differently. Well, he doesn't say how it should be written. I
I see.
intuit that what
Yeah.
he thinks is the contract should have said, if you do something for us, then you will get paid. So, for example, if you make Google the default search engine in Safari, you
Hmm.
Apple, then you
Yeah.
will get a share of the advertising revenue that is generated. Well, let's suppose that's what the contract said.
Yeah.
What would Apple do? Well, Apple would make Google the default in Safari and get paid.
Hmm. Yeah.
So it is my view that in the end, the judge has found that Google violated antitrust law only because what to an economist is a fine point of drafting in contracts. It didn't
Yeah.
affect the outcome.
Yeah.
And because it didn't affect the outcome, I believe as a matter of law that the conduct was not illegal.
Hmm. So, yeah, well said. And the fact that Google, of course, has been trying to get access to like kind of default positions where their search engine is a default setting. How did that play out? I know that there was deposition sort of evidence presented. This was a synergistic relationship between Apple and Google. And as you said, it made economic sense to engage in this contract. So at point is the fact that, can we draw the analogy like renting a billboard space, let's say for an advertiser? You wouldn't want a competitor to be listed in that space. Is that the analogy?
It's similar. Um,
Yeah.
let's back up a little bit and talk about browser design. For whatever reason, Safari and Microsoft's browsers and Google Chrome have all been designed so that the user can choose what search engine is used when you conduct a search. Now, a lot of users don't know that, but that's how they work. And it's actually quite easy to change which
Yeah.
search engine.
Yeah.
Um, I, I made sure that I remembered how to do this on my phone by looking at it this morning. So
Yeah.
it's just a few taps.
It's
You,
literally
on,
three.
on an iPhone, you go to settings,
Yes.
Safari, search engine, and then it brings up a menu and it
Yeah.
lets you
Google is
choose among 5 search engines.
correct. Yeah.
Um, so there are exceptions, but it is the norm for the consumer to have a lot of choice over this. Consumers can be ignorant, they can be lazy, or they can just be happy enough with what they've got.
Hmm.
So defaults matter.
Yeah.
And everybody wants to be the default.
Correct.
And whoever the browser developer wants the default to be something that the user is happy with. Because if the user isn't happy with the default, the user may just switch to another browser rather than go
Yeah.
in and change the search engine. So the browser developer has to choose which search engine is going to be the default. An alternative is to make each user choose, and that will be
You.
discussed as a possible remedy in this case. But it must be said, as a matter of fact, that all the browser developers decided they did not want to do that.
Hmm.
They wanted to have a default,
Yeah.
and they chose Google search largely because it was the best, but also for the money.
Yeah.
Either way, they
So
would have preferred it.
yeah, and a company like Apple, which is so conscious of user experience, would want a better browser as the default option. But definitely the idea that, as you mentioned, it Google is definitely the better search engine. They've been laser focused on its development, and that's their absolute core. That's what they look at, and the fact that they really paid attention to the mobile space up front it seems like the competitors miss that opportunity, uh, and are bringing that.
Yes.
That's a major point of contention here. Is that while Google has made vast innovations in its search engine over time, and that exhibit is also provided in the case, which is quite compelling. There have been no such improvements in other. So the fact that Apple entered into this agreement offering that as the default option, we know in economics and behavioral economics, I think Antonio Rangel provided some evidence here that default is the way that people stick to it. There's stickiness, and there's, but to your point, and it's so easy change that default option at any time with literally 3 clicks on the mobile. And I think a lot was made about the fact that in desktop it is easy to change, but not in the mobile, not in a iPhone, or simply because the space is very limited. That's subject to some contention, I believe.
Exactly. I was shocked by these claims that it was a lot easier to change the default in a PC than on a phone because it couldn't be easier on a phone. I mean,
Yeah,
it's just super easy. It's less
it's,
than a minute.
I know.
Uh, so, and I think it was overkill to spend so much trial time talking about what was called the power of defaults.
Yes. Mhm.
Now, I think that expression has utility. There's something to that. The basic idea,
Mhm.
though, is pretty obvious. Everybody can put themselves in the position of the hypothetical consumer. If you're happy with what you got,
Mhm.
then you don't go looking for something better.
Yeah. Yeah.
Any economist, at least, understands that's how the world works. And I
Yeah.
think a non economist does as well.
Yeah.
So the question is okay, defaults matter.
Mhm.
Sure. How much? Well, that turns out to be a hard question. It
Yeah.
doesn't, we didn't need to answer it in this case, frankly, but it's a hard question. It is easy to say, as the government did, that
Mhm.
a very large fraction of the users didn't switch away from the Google default. But Google responds, well, they didn't switch away from the Google default because Google is a really good search engine and they're very
Mhm.
happy.
Yeah.
And there is a lot to that argument. We also have this fascinating experiment, which is
Yeah.
mentioned in the opinion, performed by Microsoft. Microsoft, of course, does not distribute Google. Microsoft continues to be the dominant PC operating system, Windows. Windows is shipped with only Microsoft's browser, which is now called Edge.
Mhm.
Edge uses the Bing search engine as the default. You can switch it. Some users have switched the search engine used by their copy of Edge or their copy of Internet Explorer to Google.
Yeah.
Many more have simply downloaded Google Chrome. The data in the case show
Mhm.
that from 2013 to 2021, 78% of the search queries made on Windows PCs went to Google's search engine. So here, the power of defaults was overcome.
Yeah.
Google does almost as well on the Windows desktop as it does other places where
Mhm.
it doesn't have to overcome the power of defaults.
Yeah.
But
And
I'm an economist.
yeah.
I'm persuaded by the money more than anything else.
Yeah.
Google paid a lot for distribution. It thought it was getting something for its money. So defaults had to matter to Google.
So, I mean, let's take the other point, the idea of, is the search engine better? So, is there a differentiation of the two search engines?
Well,
Why don't we follow along that line? What would
okay.
happen?
I didn't actually look at the evidence on that question, but I know what the judge found.
Yeah.
The judge found, and I'm confident that he's right because he is a good
Mm-hmm.
judge,
Mm-hmm.
that the evidence showed that on the desktop, there is a difference. It is a little bit complicated, but Bing and Google search are not far apart. It is fair to say Google is better in some respects, but not much. And in many tests, Bing is faster.
Yeah.
On mobile devices, however, there is a bigger difference. Microsoft did not think that mobile search was going to be a big deal back when they needed to think it was going to be a big deal.
Correct.
They didn't invest.
Yeah.
They fell well behind.
Mm-hmm.
The judge found they have struggled to catch up and not caught up. And Microsoft admits that they have not caught up and says that catching up actually doesn't make business sense because it would cost too much. Well, that's very plausible. But the judge and the government want to say, well, that is the evidence that what Google has done is anti-competitive.
Yeah.
Because this investment from Microsoft would pay off much better if Google did not have these contracts for distribution.
Yeah.
Well, there is bound to be a little bit of merit to that. I think very little, but your question was about the quality. And in mobile search, the findings of the court are that Microsoft is well behind.
Yeah. There was also an argument made that Google engaged in this contract with Apple so that incentivize Apple to from having its own search engine. And some calculations, Google folks made saying that this much cost would be needed for Apple to develop a search engine. So there's some back calculations going on, which were also presented during the case.
That
But
is so. The judge did not put a lot of stock in this argument.
yeah,
It was a
okay,
significant argument from the point of view of the government.
yeah,
The government said one of the reasons why these contracts should be held to be unlawful is because they, as a practical matter, kept Apple from developing its own search engine. But the government did not argue the contracts were anti-competitive agreements in the collusion sense.
yeah,
They did not argue that Apple was being paid to stay out of the market. No, it was an incentive argument.
yeah,
But, incentive arguments here are kind of tricky. Apple didn't really want to develop a search engine. It could. It determined that it was a better business strategy not to.
yes,
Because they're making a lot of money without developing their own search engine, and it would cost a lot of money to develop a search engine. And in the end, they might lose the competition on search engines. So it's a risky proposition as well. So they'd rather not do that if they can strike a deal with Google on good terms. Well, they could. They did.
yeah,
Now, if that deal was ruled illegal, just full stop illegal, you can't do it on other terms, you can't do it at all.
yeah.
What would Apple do? Well, we don't know. That might be a drastic enough change in circumstances that Apple would develop its own search engine rather than use Bing, because a deal with Microsoft wouldn't generate nearly as much revenue.
Exactly.
But that doesn't mean that the deal between Apple and Google was anti-competitive because it kept Apple from developing a search engine.
Correct.
Apple didn't want to develop a search engine, and
Fair.
it found that there was a very good path forward that didn't involve developing a search engine. It took that path.
Yeah. And I mean, it's not their core competency in any case. Google is the one that has been totally focused on it. And therefore, to come up with a competition, profit maximizing companies focus on what they can do best. So
Yes, I
that
think that's an
would be
excellent
unlikely.
point that lawyers and judges don't adequately appreciate.
Yeah.
I could hear this in the comments that Judge Mehta made on the stand. His attitude was, Apple is a gigantic, technically competent company. It can do anything. Well, maybe, but that doesn't mean it should or will do anything.
Yeah.
It will get into a lot of trouble if it starts going off in all kinds of directions.
Absolutely.
Companies generally don't do that.
Yeah.
It, they pursue avenues that have technological or business complementarities that are
Exactly.
opportunities for growth, that
Yeah.
take advantage of new technologies. They
Hmm.
don't just go off in every direction where they might be able to make a product.
Yeah.
You know, Apple might be able to make good cars, but
Yeah.
it makes a lot of sense for them not to make cars.
Mhm.
And
And so,
it made sense for them not to develop a search engine.
and I mean, so let's look at the counterfactual. Or what if Google did not engage in this contract? Then Apple would have been short of 20 billion in its, and let's say at the top of your screen you have which search engine do you want to choose. I'm pretty sure that, again, uh, there would be a so-called monopoly situation, because people would seem to choose that more, because of its brand, because of its quality of its searches. So, uh, is that something that can the judge outlaw this kind of contract, and tell the businesses how to pursue and negotiate with their partners in this case?
Well, if you're asking me, is that within the powers of the court? The answer is yes. The judge has a lot of power to reshape the industry, certainly to reshape the contracts, to ban certain contracts, to ban certain terms in contracts. Requiring things is a little more difficult. Prohibiting
Hmm.
things is very easy.
And is that kind of scenario likely?
Well, now we're getting
It's
into the remedy.
okay.
And
Okay.
one thing we
We'll
know
hold
for
off.
sure
Yeah. Yeah.
is that the remedy will prohibit certain contracts or certain contract provisions.
I see.
My guess is
Okay.
it won't prohibit contracts, but just contract terms.
I
It will
see.
not say that Google may not contract with Apple for distribution. It will
Hmm.
say that Google may not enter into exclusive contracts
Yeah.
with Apple, and it will say that an exclusive contract has these characteristics
Correct.
so that
Correct.
you can't do it that way. Find another way
Yeah.
to do it.
Yeah. Should we talk a little bit about contracts with the suppliers and the equipment, OEMs, and the Android ecosystem that Google developed, and how was that taken by Judge Mehta, and where do you think that is headed? Because this was a business strategy to have its search engine on in the mobile space and having those in the box default options, and other companies could load their software, but that the search engine had to be there in those devices, and it's
Right.
contracting with AT&T or Samsung. um, how does that play out in terms of this case, and what were the arguments that were presented?
Okay. First, some basic facts here. So, distribution of search engines in the Android environment involves two kinds of players. It involves the manufacturers of the devices, like Samsung,
Hmm.
and it involves the mobile carriers who are the main distributors of the devices.
Hmm.
Both of them have licenses for Android and distribution agreements with Google that involve what I'm going to call placement.
Okay.
So the contracts say that Google Chrome and the Google Search app must be placed on the device. The contracts say, well, they say something about how they'll be placed on the device, where and the real estate they will appear. Those things vary from device to device, from carrier to carrier. To a considerable extent, Google's partners got to choose how they wanted to promote Google's search engine, with the understanding that the more they preferenced it over other search engines, the more they would get paid. So if you wanted to distribute another search engine, you could.
Yeah.
But you wouldn't get as much money if you did that. So if you chose to distribute only one browser, Google Chrome, and one search app, Google Search, then you would get a higher revenue share than if you didn't grant exclusivity. So their exclusivity was a choice, but it was a choice that in some cases was made. And the record doesn't really show how often it was made.
And again, that's a fair contracting term, would you think,
Well,
from the business
certainly.
standpoint?
Well, yes. The first place, if you are distributing these devices, you're not going to load them up with apps that do the same thing. In some cases, you may give two, but most likely you're going to prefer to give one. And you're going to realize that if you only give one, then you can generate a competition between app developers. I will distribute your app and not the other guy's app if you give me money. So this is the thought that goes through the mind of the device manufacturer or the mobile carrier. And the logical partnership, of course, is with Google. Google's the developer of the Android operating system. They develop it in order to promote the use of Google search, maybe for many other reasons too, but that was a major reason. And it works, of course. So this is a natural partnership. It's a partnership that takes place. It's a partnership that ends up promoting Google search. But there was always going to be a partnership. It was always going to promote one search engine over another, one browser over another, because that was the way to produce a product that would appeal to consumers and that would generate revenue. The device manufacturers and the mobile carriers get substantial revenue from Google for promoting Google. It is very logical for them to enter into these partnerships and get that revenue, which then will affect the terms on which it deals with end users. End users have a choice of buying the device and then getting a data plan that is cheaper than a data plan that comes with the device. Many users like that second option, the one where the device is paid for out of the monthly charges. Whichever of those plans the consumer gets, the fact that the device manufacturers and the carriers are getting revenue from Google will affect the price. It has to, in equilibrium. Any economist would see that. Exactly what the effect is may be hard to figure, but there's an effect and it's significant. But the judge says it was unproved. And here's where lawyers and economists just don't think the same. Time and again, things that were obvious to any economist or probably any business person, the government would say in court, these things weren't proved. And why wasn't there documentary evidence to prove these things? It must be because they're not true. Well, it could be because they're obvious.
So, that's interesting. But I mean, so the end consumer is paying less because of Google's Android ecosystem, right? Is that correct to infer?
Yes. If the device makers and the carriers are getting a lot of revenue from Google, then competition among device manufacturers and among carriers is going to cause them to lower the prices they charge the final customers. The relationship may be complicated, but there is one and it's strong.
And that's why the adoption of the Android system is much more affordable in other countries as well. That's fair to say, correct?
I don't
Yeah, but
follow that
yeah,
closely, but
yeah, yeah,
it makes sense.
yeah. So if that is the case, I'm thinking, was a lot of data presented by the defense in this case? Because as you said, it seems obvious. Did they actually make the arguments and showed it so that it was obvious to the judge that this is what is happening? And I'm also very curious about this divide, so to say, between the lawyers and the economists. And does the legal prevail always, even when presenting evidence, especially from the company's side?
Well, you asked a bunch of questions. First, on data. Yes, there was a lot of data in the case,
Hmm.
and unfortunately, a lot of it's redacted, so we can't see it.
Yeah,
Um, and that's too bad because there might
yeah,
be some interesting insights that I'm never going to have because I can't
yeah.
see the data.
And
But
I was trying to, yeah, I was
that's the
exactly
nature of
trying
these
to say.
cases.
Yeah, correct,
Um,
correct.
Company-specific data is limited,
Mhm.
especially for companies other than the defendant.
I see.
We have market shares. We have good
Hmm.
market share data in the record, but much data that might lend to insights is not available.
Yeah.
And it was not explained how certain things were calculated. So there's a lot I don't know about how the data are even generated in this
Hmm.
space. But there
Yeah.
is a lot of data. They know things
Yeah.
that you wouldn't think they would know, but they know them. So that they can keep track of, um, what browser, what search engine, what version of everything is connected to an individual search query and total up all of this. And somehow the one of the government's economic experts was able to determine that just under half of all the search queries in the United States went through defaults contracted for by Google. I don't know how it was exactly possible to generate this data and
Mhm.
do this calculation, but it was done. I assume it was done competently. No reason to doubt that it was. Google didn't objected to the inferences to be drawn from this calculation, but didn't say the number was wrong. So, so there was a lot of data, and a lot
Yeah.
of things were known.
Yeah.
Only some of which we get to learn.
I see. Because yeah, I was
Uh,
trying to find the information, and there's no data here. Of course, it has been redacted, and it's not available for outsiders to.
yes, and it was
Yeah.
frustrating to sit in the courtroom. There are hundreds, probably thousands of trial exhibits, and I don't know, more than 50 of them are graphs,
Yeah.
and about 90% of the graphs are completely blacked out.
Yeah. Correct.
You couldn't see anything sitting in the courtroom.
Oh, in the
It,
courtroom as well.
yes,
I see. Because I'm looking at the published documents, and there is nothing.
yeah. But my point is, you sit in the courtroom, and they put these slides up, and it's black. You have the axes.
Yeah, just like yeah, correct.
So yeah, that was unfortunate.
Yeah. So I have a question. I think there's something that you have worked on, the hypothetical monopolist test. Was that presented by the plaintiffs in this case for how they came up with
Um,
pursuing this allegation, or was it not
Yes and
presented? And
no, and mostly no. First, it must be said that applying the hypothetical monopolist test in this case it would be very challenging
okay,
for a whole variety of reasons. But first and foremost is that search is not sold. So the
zero price.
usual
Yeah.
straightforward way you would think about this case is to think about raising the price and
Hmm.
see what happens. Well, that's not how it works. So it is possible, in theory at least, to apply the test with data
Hmm.
analytically correctly, but I'm not sure you can do it as a practical matter, and it wasn't attempted. It's also the case that the head of the Antitrust Division is pushing back against the hypothetical monopolist test. So the government made a point of arguing that, well, sure, you could do it that way, but there are older ways to do this in the case law that are still perfectly good. Well, of course, they never made any sense. But the government's expert wasn't permitted to say they don't make any sense.
Oh.
And the judge relied on them, although much of the reasoning leaves much to be desired there. And I don't want to spend a lot of time going into this. None of it really matters. There are substantial questions raised by Google about whether it should be found to be a monopolist. But it is not surprising that Judge Mehta found that it was a monopolist. Not surprising in the least. I would have been shocked if he'd have found anything else. Google made an argument that I mostly agree with, that the way to think about defining the market here is to put yourself in the position of user and think about what the user is trying to do. And then in the answer, what his alternatives are depends on exactly what he's trying to do. So the government has talked about this market for general search engines.
Yeah.
And the idea is that it's the search engine to which you can direct any query. It's general. But there are all these specialized search engines to which you can direct many of your queries, and people do. And so Google argues that it competes with lots of other things, like Amazon and like social media.
Yeah.
And in a way, it certainly does. There's just no question that there's competition there. And the judge found, yes, there's competition there. And there's competition to sell advertising to users between Google and these others. And Amazon makes a lot of money from advertising, does Facebook and other social media. They've all realized that advertising is a great way to make money. And advertising is very complicated. Advertising is where the money is here, so it's what you have to think about. And from this perspective of advertising, substitution is very complicated. I can't think of anything that's more complicated to think about substitution in than advertising, because advertisers put together a portfolio, and there's substitution among many margins in this portfolio. And so there's evidence in this case about how they would shift between media and between Bing and Google. It is probably right to conclude, as the judge did, that the evidence shows that there isn't much substitution at the margin. Google really is a monopolist. I thought that was a foregone conclusion. Had I been advising Google, they probably would not have contested the issue. And they should not contest it on appeal. They're wasting their time.
Wow.
But monopoly's legal.
Yeah.
They got to be a monopolist fair and square.
Yeah.
And
yeah.
I think from a point of view of the narrative of the case, I would have wanted to say, if I am Google,
Yeah.
yes, we're a monopolist. We're that much better than everybody else that we dominate the space.
So come out head on.
And that's why we keep winning.
Yeah. But okay, so just going back to this point, the judge, or I don't know, this evidence was presented, the Nike boycott of Facebook and what happened to the advertising across the different media. Is that something you recall?
I remember that evidence is in the case. I was even in the courtroom at the time, but I don't remember the evidence.
Yeah. Talking about substitution between different...
That's the kind of experiment that's frequently used in antitrust cases because it's what you have. You use what you have.
Yeah.
Economists are used to that. They don't conduct experiments. They use the data they have. So this is something that is frequently called a natural experiment, although it's a very unnatural thing to have a boycott like this. So you can see where the money goes. But one of the things I remember seeing is that it's actually kind of hard to figure out. There's a short-term effect and a long-term effect, and it doesn't necessarily replicate the marginal effects that you care about. You care about effects of small changes, not big ones. And sometimes you can interpolate from large changes and see what the small changes would be, and sometimes you can't.
Yeah. Another point that I wanted to bring up in our conversation, the Gen Z. I mean, is there a difference in the generational way in which they are accessing search across media, social media, especially for commercial query search? Is that
I
playing a
think
role
that's
here?
probably true, but I don't remember any evidence on the subject.
Okay, because that might, talking about does it have a monopoly on uh,
Yeah, since I'm
some.
old, I cannot put myself in the position of somebody who's young.
Okay, well, that's not true, but sure. And, I also wanted to bring a point which I was thinking about, this concept of the default search, just going back a little bit. There is that the search engine, which DuckDuckGo, which is used by people who care about their privacy much more. So those kind of users will immediately go and change the default. So again, it depends on the users who are the savvy users, so to say, will not uh, go with the default option.
Yes, as a matter of fact, while this case was going on,
Mhm.
I explained some of this to a friend of mine who's even older than me. And I explained that he could change his default search engine on Safari. And he
Yeah,
said, really? Show me. And
yeah,
and we got his phone and we tapped,
mm,
and I brought up the menu and I said, read off the choices.
mm.
And he said, oh, I think I'm going to try DuckDuckGo. And he taps on DuckDuckGo. And,
Yeah,
and I'm sure he doesn't even remember doing it. So
and now
so
that's his default.
all his searches are through DuckDuckGo.
Yeah, yeah,
That's a choice
yeah,
that Google in no way tries to block.
yeah, because so niche.
On the other hand, because of the way DuckDuckGo's business model works, their design is completely different. If you use
Yeah.
the DuckDuckGo browser, you must use the DuckDuckGo search engine.
All right. So, well, we should conclude. What can we expect from him next in terms of what happens to Google, and also what are the widespread ramifications then for big tech? What can they expect, given this ruling? Um,
Well, I don't think the ruling has any particular repercussions. There's
mhm,
there's a lot of virtual ink spilled on this subject, but I
mhm.
think it's something nobody should bother to read because
The timing
other
of it. Yeah,
cases are
yeah,
going on. You should look at the specific, not the general.
hmm,
There's several other Google cases even.
yeah,
Uh, so what's going to happen? Well, there's going to be proceedings. They're probably going to be
yeah,
elaborate. They're going to take months. I would
hmm,
guess that we will get a remedy order in the spring, probably late spring, um,
hmm,
like maybe June. It's not an easy question. It will
hmm,
take a while to get proposals together. People in the government, including in the states who are co-plaintiffs here, have said they're thinking about lots of different remedies. I'm sure that's true.
yeah,
Absolutely sure that's true. That may be a problem with this case. I think they should have gone into this case knowing what remedy they wanted, and they should have said so in the opening arguments of the case. But that's not how it worked.
yeah.
So they have done what's called in law bifurcation. The issue
Okay.
of remedy has been separated from the issue of liability. They do
Hmm,
one, then the other. The,
hmm,
they argue to the judge, this is efficient. You don't have to think about remedy if you're not going to have to impose a remedy. So
hmm,
put that off. Judge says, sure, I put that off. Well, I think
hmm.
that's the wrong way to do it because unless you know what the alternative is, how do you know
Yeah.
that you want the alternative? Why would you make a blind choice to do something different if you don't know what the different
The
thing is?
different thing is how. Well,
So there's a lot of speculation now about what the different thing is.
I see.
And it is just speculation.
Hmm.
I do not think there will be a major restructuring of the company. I think it would be pointless to divest Google Chrome or the Android operating system.
Yeah.
Remember, neither of these things right now is a business. Neither of them generates profits.
Yeah.
So a new owner would have to turn them into profit generating businesses. Well, how would you do that? A
By
new
engaging
owner
in
of
agreements.
Chrome would
Yeah.
make a deal with Google on terms that look a lot like the deal between Google and Apple.
And Apple.
Is that
Correct.
better? And who's going to want Android? Well, probably Samsung. What would Samsung do with Android? Well, what it's doing with Android now,
Yeah.
is it going to want to pursue a relationship with Google? Well, yes. Is it going to look a lot like the relationship they have now with Google? Well,
Yes.
yes, it is. So what's going to be different? Well,
Yeah.
nothing.
Yeah.
So what's the point? There isn't any. It's a grand gesture that's completely empty. There's a lot of written about, well, you just have to do something to open up the market. Well, you don't have to. Seriously,
Yeah.
it's not a joke. You don't have
Yeah.
to. In fact, as a matter of law, you have no basis to do that. There is an important point in the DC Circuit's Microsoft decision from 2001 that the judge is going to go back to now, which says that the appropriate remedy has a lot to do with the anti-competitive effect it's actually been proved.
Yeah.
The court in Microsoft said that the effect had been proved wasn't that substantial. So the remedy should be proportionate. Well, in my opinion, even less has been proved in the Google case. The Google decision does not say that were it not for these particular terms in these contracts, the world would have evolved differently. It doesn't
Yeah.
say that Google's share would have been less than 90%. Doesn't say that the rivals probably would have invested in improving their products. Doesn't say any of those things.
Yeah.
And maybe Judge Mehta was right to say, well, I don't have to find any of that to find Google liable. I don't
Yeah.
agree, but maybe he was right. Well, but he didn't find those things. And he will choose a remedy that's proportionate to what he did find.
Yeah.
Um,
So
but the drastic remedies would also just turn out to be punitive. And the
yeah.
first principle of remedies is that they cannot be punitive. People keep writing, well, it's not enough to punish Google. Well, what do you mean not enough? It's not even permitted to punish Google.
Permissible. So fines are not an option.
No, and there's a piece in the Washington Post last Saturday that made my blood boil, so to speak.
Oh. Oh.
They had staff journalists speculate about remedies in the
Oh.
Google case. Well, how sensible is it for journalists to speculate about the appropriate remedies? They don't know anything about antitrust law. They don't know about this industry. What is their basis for the speculation? And one of them, of course, says, well, maybe it should just be a fine. Well, it cannot be a fine. That is not an option available to Judge Mehta. No matter how much he might think it's the right answer, it's not an answer he can give.
Okay. Interesting that in this case, the competitor is Microsoft. So it's like we loop back to Microsoft decision. So there was this argument, and maybe just elaborate on it for a few minutes. Harm to the anti competitive process. That's what is required in this ruling, as opposed to harm to a competitor. Is there a distinction?
Oh, absolutely. It's a very
Yeah.
important distinction.
Yeah.
And at times it's a tricky distinction.
Yeah.
So it should be common ground, but isn't always, that the antitrust laws exist for the sole purpose of protecting the competitive process. Many court opinions say that. I have written a lot about that. That's my starting point. I don't think Judge Mehta has said anything that's contrary to that. And in some cases, there's clearly a distinction. So imposing a remedy that serves no purpose other than to benefit Google's rivals
Yeah,
just
it's not
isn't what antitrust is about.
exactly.
It's about enabling competition,
Hmm.
not helping competitors. So,
Correct.
basic idea, as I understand antitrust law, and as my book explains it, is that anybody, even a monopolist, is entitled to do whatever he thinks is best to make consumers like and buy and use his product. What he's not allowed to do is make it harder for his rivals to do the same thing. They still have to be allowed
Hmm.
to do what it takes to make their customers want to buy their product.
Hmm.
So the difference is Google handicapping its competitors or is it just promoting its own distribution?
Yeah.
What Judge Mehta found was that it was handicapping its competitor. The key question on appeal is that right?
Yeah.
I don't think it's the right way to think about it.
Hmm.
But Judge Mehta understood that that was the question.
Hmm.
But he interpreted those contracts as a practical matter to be handicapping competitors rather than promoting
Their
Google's
own.
distribution.
Hmm.
And that's why he ruled that Google violated the Sherman Act.
Okay. Well, very well said. And this has been a great conversation. The whole purpose here was to get you, the expert, and with your vast experience, I'm very thankful you're sharing it in my podcast. And again, as a disclaimer, we are interested in the economics and going to the root of the issue and not promoting any political viewpoint. So I'm very, very happy. And thank you so much for your time. And most importantly, thank you for your patience in trying to explain to an audience that might care about this topic. So thank you very much, Greg,
You're welcome.
and we'll meet again. Thank you.
Goodbye.
All right. Bye bye.